This is the mini-series of the University of Idaho murders, episode 1.
We're starting to win over Bonner.
Some very interesting details about why investigators have linked him to these murders. One, the biggest clue so far is a tan leather knife sheath that was found next to one of the victims. They found DNA on that knife sheath. And as they were investigating a 2015 white Hyundai Elantra, they linked it to Kohlberger, and that's when they really started surveilling him. They found some trash at his parents' house and they took some DNA from that, and that's how they were able to get a match to link him based upon the fact that cell phone records, the forensic evidence there, the several. They're saying that there were 12 different times that his cell phone pinged near that residence before the murders, and they say that that's usually an indication that someone is staking out a crime scene before they actually commit those murders. Vicki, Savannah?
Savannah, these clues coming out of the affidavit showing why he was arrested. We know that he is going to make, or has made, his first court appearance back there in Idaho. Walk us through what happens next.
Question. Have you read, seen, or heard if police found a knife sheath on the bed next to one of the victims? Question. Have you read, seen, or heard that DNA found on the knife sheath was later matched to Brian Kohlberger?
The damage has been done. We've been working very, very hard to keep the sort of noise out of the case. And now it's been injected, at least to these 400 people.
Nobody's injecting anything into the case. A random small percentage of the population is contacted. Have you read, seen, or heard things that are lifted straight out of the media?
Welcome to the Transparency Suppression Eve.
Today, he's charged in the stabbing deaths of 4 University of Idaho students last November. The defense today questioned the validity of the DNA found in the knife sheath allegedly connecting Kohlberger to the murders. They are demanding more information about that DNA from the prosecutors.
They have provided full discovery for the sheath, the DNA found on the knife sheath, but not the other 3 unidentified male DNA samples.
Prosecutors say they've handed over what they have.
We have given the defense everything that we received from the lab. They've asked for DNA workups on other people. To the extent that they don't have them, they weren't done. We can't produce something that doesn't exist.
Police arrested Kohlberger at his family's Pennsylvania home back in December, more than 6 weeks after the gruesome murders set off panic on the Idaho College campus. His attorneys argue he's innocent and was out driving alone at the time of the murders.
Is that a strong alibi?
No, it is not.
Criminal defense attorney Joe Tamburino, who is not part of this case, says it's a weak argument.
But an alibi defense is not, I simply wasn't there at the time. It's you must provide specifically where you were, time, place. Also, if you have any witnesses.
The defense had also been trying to delay the trial. Just moments ago, the judge ruled the trial will continue as scheduled in October. The victims' families were inside the courtroom and said they are optimistic.
Welcome to the Transparency. Make yourself
killings.
known.
New documents just unsealed show that prosecutors say DNA left on a knife sheath was used to link Brian Kohlberger to the murders. And one of the surviving roommates came face to face with him that night. News Force Chris Glorioso has been looking at it. He's in the newsroom with details. Chris?
David, police believe Brian Kohlberger was a sophisticated killer using his advanced knowledge of criminology to try and outsmart investigators. But the court documents released today say he made a monumental blunder, leaving that knife sheath next to one of the victims. Police say forensics on that sheath, combined with cell phone and vehicle records, all point to Kohlberger as the killer.
I am going to leave the bail set of this case as no bail.
28-year-old PhD student Brian Kohlberger will have to fight his murder case from behind bars for now.
There she is, the subject of everything. Magistrate Judge Megan Marshall. It is Suppression Eve. Yes, Suppression Eve. Some people in Georgetown specifically, they are drinking in bars right now. They
aren't like football fans and show up on Sundays, they show up to their local bars at noon and they are blasting like CNN, any type of news coverage in these bars, and everybody is literally fist pumping because they love this shit.
His first court appearance, Idaho.
When I say that, I'm not talking about murders. I'm talking about they love law. They love, like, think about like the debate. Your family members at Christmas that want to debate you on whatever it is. And, oh, God, I don't want to see Uncle Harry. He's just going to talk about, politics or whatever. This is what they enjoy. People enjoy the hobbies of collecting, baseball cards. And but their hobbies are, hey, I love law.
Prosecutors argued he was a flight risk because police found him 3,000 miles away from the murder scene at his parents' home in Pennsylvania. It turns out that house is where critical DNA evidence was harvested from the trash. According to this unsealed affidavit of probable cause, first, an Idaho lab located a single source of male DNA left on the button snap of a knife sheath next to one of the stabbing victims. Then, Pennsylvania agents recovered that trash from Koberger's family residence. DNA from the trash and DNA from the knife sheath identified a male who could not be excluded as the biological father of Koberger. Koberger's father is not accused of any crime. This is police body cam video showing both father and son pulled over for tailgating as they drove cross country from Washington State to Pennsylvania.
Mr. Koberger, you're tailgating, baby. Pulled over for tailgating not once, but twice.
About a month after the stabbings, Brian Koberger was arrested in his family's Pennsylvania home last week. The public defender who represented him said Koberger planned to prove his innocence.
He believes he's going to be exonerated. That's what he believes. Those were his words.
In order to beat the case against him, Koberger will have to explain not only the DNA on that knife sheath, but also cell phone records cited.
It's interesting that they would say that Koberger is going to have to explain that DNA. I thought that the state would have to explain their case. But here, mainstream media believes that Koberger is going to have to explain that DNA on that sheath. Welcome to Truth and Transparency. I have a great show lined up for you guys, and I'm sure that mainstream media is watching. So make sure you guys get out your, I actually came up with my cue cards to help out mainstream media when I'm laying it down here with Hector. So Truth and Transparency investigates. Here we go. Come on in, thumbs it up, thumbs it down. I don't give a shit. If you're here, it's great because you wanna know what's going on, and you know that Lana's gonna be honest. And I'm going to honestly tell you right now, the defense. This is a huge uphill battle. This suppression hearing, most notably the Franks, because our laws and case precedent protect, and I'm going to show you that they protect law enforcement, they protect magistrates from you have to meet a high threshold, okay, to prove that, hey, guess what, you lied, and you lied and you did it intentionally, because that burden that we are facing tomorrow with this hearing is on the defense. So not normally do you hear that the defense has the burden. Yes, in a suppression hearing, the burden is on the defense, and they have to show a preponderance of the evidence to even get the judge to allow them to have a Franks hearing. Okay, we're going to go over what all those words mean. Again, welcome.
In the affidavit, before the 4 University of Idaho students were stabbed to death, police say Koberger's phone pinged cell towers near the crime scene on at least a dozen occasions, suggesting he was scoping out his victims. They say his mobile phone did not communicate with nearby cell towers during the hours of the stabbings, but the affidavit suggests that is consistent with Koberger attempting to conceal his location during the quadruple homicide. One of the most chilling passages of the affidavit unsealed today comes from one of the two surviving roommates in the apartment. She told investigators just after 4 a.m. in the morning of the killings, she heard crying. She opened her bedroom door and was frozen in shock when she saw someone in black clothing and a mask who walked right past her and out the apartment's back door. The mask, she said, covered the killer's mouth and nose, but the roommate told police she could see bushy eyebrows, and police described Kohberger as fitting her description.
Again, welcome to Truth and Transparency.
Welcome back, everybody. During the Idaho College student murders investigation, Moscow police contacted the makers of the knife believed to be the murder weapon. The probable cause affidavit says that officers found the sheath to a K-bar knife next to Madison Mogen's body. DNA on that sheath helped police connect Brian Kohberger to the scene. Now, the director of sales and marketing for K-bar told TMZ that investigators contacted the company about the knives and sheaths they sell, but K-bar did not have any records of someone named Brian Kohberger purchasing one. Experts say the knife that would fit the sheath is a 7-inch utility knife, commonly used as a tool by campers or hunters. While police haven't found the knife itself, the sheath with Kohberger's DNA is on it. It's a pretty big get for the prosecution. Wouldn't you agree, Terry?
Come on in. Come on in. Suppression Eve. First question for you guys is, what proffer was made by the defense to push for the Franks? Now, you guys are probably saying, well, Lana, what is a proffer? Well, it's when you proffer and produce material to, here in this situation, to the judge, Judge Hippler, to say, here you go, this is our proffer to show, and it's going to be a pretty big, substantial push with material and or witness testimony contradicting statements in the probable cause affidavit. We know that the defense made a proffer. They may have made a couple proffers, but there were proffers offered up. And what that means is that the defense went ahead and said, here you go, Hippler. Here's all the stuff. Based on what we are claiming, here's the evidence, the material that's supporting what we're saying, which is contradicting what is in that probable cause affidavit and should have been known, and then was recklessly omitted. Complete disregard for the truth. That's the proffer. And we know for a fact, based on documents that have been read out on this channel, it's in court documents by the defense that proffers were made, at least one. You're probably saying, well, Lana, what do you think that proffer was? Well, I'm going to tell you right now, I'm putting all my chips on the proffer being Cy Ray and his data compared to what the probable cause affidavit has suggested, showing that it is faulty. The data was faulty. They never went out and documented the data points. And so to connect, to say that the phone and the car were moving in concert, we have direct, here you go. This proves that the phone and the route that they say, here it is. The phone was not doing that. Lana, could there be other proffers? We'll get into that. Next up, the burden lies on the defense. So this is number 2. The burden lies on the defense. I'm going to replay this intro for the purposes of truly understanding how mainstream media has portrayed this case like Brian Kohberger has to prove his innocence. Because for whatever reason, we here in the United States of America, when listening to mainstream media, we and everything that we would have ever learned in our life, when you turn into mainstream media, it's like, well, when did it switch that the defendant has to prove their case, prove their innocence versus being, I'm innocent until y'all prove me guilty, right? So check it out. Welcome, Miss Potts. I've been waiting for her to join me. We've been waiting for this probably for, 2 years. 2 years. Can you guys believe it? But tomorrow will literally be 2 years to like the day that Ann Taylor received a huge data dump of discovering this case. It's been 2 years.
This is the mini-series of the University of Idaho murders. Episode 1.
We're starting to win over Bonner.
Some very interesting details about why investigators have linked him to these murders. One, the biggest clue so far is a tan leather knife sheath that was found next to one of the victims. They found DNA on that knife sheath. And as they were investigating a 2015 white Hyundai Elantra, they linked it to Kohlberger, and that's when they really started surveilling him. They found some trash at his parents' house and they took some DNA from that, and that's how they were able to get a match to link him based upon the fact that cell phone records, the forensic evidence there, the several.
She doesn't know what to say. That's all she could say. The several. Wait, what else is in the probable cause?
They're saying that there were 12 different times that his cell phone pinged near that residence before the murders, and they say that that's usually an indication that someone is staking out a crime scene before they actually commit those murders. Vicki, Savannah?
Dana, these clues coming out of the affidavit showing why he was arrested. We know that he is going to make, or has made, his first court appearance back there in Idaho. Walk us through what happens next.
Question. Have you read, seen, or heard if police found a knife sheath on the bed next to one of the victims? Question. Have you read, seen, or heard that DNA found on the knife sheath was later matched to Brian Koberger?
The damage has been done. We've been working very, very hard to keep the sort of noise out of the case. And now it's been injected, at least to these 400 people.
Nobody's injecting anything into the case. A random small percentage of the population is contacted. Have you read, seen, or heard things that are lifted straight out of the media?
This case has been controversial since day one. But why?
Today, he's charged in the stabbing deaths of 4 University of Idaho students last November. The defense today questioned the validity of the DNA found in the knife sheath allegedly connecting Koberger to the murders. They are demanding more information about that DNA from the prosecutors.
They have provided full discovery for the sheath, the DNA found on the knife sheath, but not the other 3 unidentified male DNA samples.
That's right, America. There are not 1, 2, but 3 unidentified male DNA samples. Come again, Lana? Yeah, 3. Like, not like one person. There's like 3 samples around the house. 3 separate individuals that are male. Unidentified DNA in that home. And 1 of them was actually outside, right outside, on a glove, and it was not Chris McDonough's glove that he found. And 2 were right where the deceased were located.
Prosecutors say they've handed over what they have.
We have given the defense everything that we received from the lab. They've asked for DNA workups on other people. To the extent that they don't have them, they weren't done. We can't produce something that doesn't exist.
And that's been the reoccurring theme here for the prosecution for the past 2 years is we can't produce something that doesn't exist, that we don't have. We don't have it. Bill Thompson's screaming, we don't have it. It doesn't exist. That's been the state's motto for the past 2 years. And now tomorrow we're going to find out if that actually holds true. It doesn't exist. Does probable cause exist? Everything else doesn't exist in this case. Well, does probable cause exist? That's what tomorrow is all about. Did the police have probable cause with the information that they provided in search warrants to then obtain the information that was granted in these search warrants by Judge Megan Marshall based on what she believed these officers were saying? And that burden is so, it's a high threshold to show that a Frank's hearing is merited, and we need to take a look at this because, wow, you have to make a strong preliminary push. And the proffer, if there's multiple, that I believe was offered up is the data is not that was portrayed in the affidavit, as well as here's number 2, that they led the tribunal, which would be Megan Marshall, to believe that they found Brian Kober on November 29th from WSU queries, and that the language in there suggested that they had Brian Kober on November 29th, and that Moscow Police Department knew that and was working then, compiling their case back then. Not what Payne then would testify to, that he did not know the name Brian Koberger until December 19th, 2022.
Police arrested Koberger at his family's Pennsylvania home back in December, more than 6 weeks after the gruesome murders set off panic on the Idaho college campus. His attorneys argue he's innocent and was out driving alone at the time of the murders.
Is that a strong alibi?
No, it is not.
Criminal defense attorney Joe Tamburino, who is not part of this case, says it's a weak argument.
But an alibi defense is not, I simply wasn't there at the time. It's you must provide specifically where you were, time, place. Also, if you have...
Exactly. You must provide time, place, where you were. Brian Koberger's alibi defense is not in the traditional sense of, in 1970, Joe Smith here is going to tell you I was with him playing pool or playing video games. Joe Smith is my alibi. No. In this case, in 2022, just like how police arrest us based on our phone data, based on where we were, based on our phone telling the police where we were, and them using it as circumstantial evidence to convict us in cases such as murder, Brian Koberger is using the same type of information, data, phone data, with an expert testifying to, based on Moscow Police Department's assertion that Brian Koberger was with his phone that night. Because of them saying that, and that he just simply turned off his phone, then having somebody like an expert saying, well, you're saying he's over here and I'm saying he's over here. And the difference is what's the data? Is the data going to support what Moscow Police Department's saying? Or is the data going to support what this expert is saying? And so it would come out that Brian Koberger was at some park, completely in a different state, a neighboring state of Idaho, but nonetheless in a different state.
Any witnesses?
The defense had also been trying to delay the trial. Just moments ago, the judge ruled the trial will continue as scheduled in October. The victims' families were inside the courtroom and said they are optimistic.
Number 3 now. Who are the defense's witnesses? They have subpoenaed 3 people. Does that mean that they're only calling 3 people? No. This is like, hey, we have to subpoena these people because maybe other people that we're going to have as our witnesses, we don't need a subpoena because we know that they're going to be there. But right now, we know for sure the defense, 3 people, of which all of them, some of them, one of them, they have got it approved for tomorrow and then on Friday to be able to give their testimony under oath over Zoom. I'm going to throw up a wild card here. I've done a lot of research in the past 12 hours, really looking into this a case, State versus Peterson. I believe that the prosecution is going to heavily rely on an Idaho Supreme Court case, Idaho versus Fisher, when they're going to be talking about negligence, when they're going to be talking about this probable cause affidavit, as well as State versus Peterson. And I'm going to tell you, after, like I said, hours of research, I'm going to tell you how not being a lawyer, where my logic and common sense would go on how to spin State versus Peterson with this case that we're dealing with. Because everything in law is a spin job. And it's all about covering yourself on all the axes that this spin job is happening. You want your arguments to literally be, if they say something, you have this. If they then go this route. So think about like a circle, and you have a ton of different ways. You need to keep your head on a swivel because a ton of different ways things could be coming at me. That's when I think about case law, that you need to have how you're going to argue that something could fall under, and I'm going to get into that with State versus Peterson. So again, who are the defense witnesses? Ultimately, you have to ask yourself, who can prove your claims and arguments to that judge, Judge Hippler? The only reason you are calling people to the stand in this case for this specific hearing is for this specific reason. So in order for the defense, because it is on them, the burden is on them, in order for them to win, in a sense, the suppression hearing, you are going to need people that when you make claims that are able to back up your claims. You need data or information that's going to back up your claims. Throwing up blanket statements and then saying, which we'll get into, we'll get into that.
College student killings. New documents just unsealed show that prosecutors say DNA left on a knife sheath was used to link Brian Koberger to the murders. And one of the surviving roommates came face to face with him that night. News Force Chris Glorioso has been looking at it. He's in the newsroom with details. Chris?
David, police believe Brian Koberger was a sophisticated killer using his advanced knowledge of criminology to try and outsmart investigators. But the court documents released today say he made a monumental blunder, leaving that...
Blunder. It's a blunder. It's a blunder. How you doing out there, Annie Potts? I know Annie Potts is probably making chili, sitting all curled up with, her finest wine, boxed wine. She has her little twisty ties all ready for her game that she's going to play with herself.
Knife sheath next to one of the victims. Police say forensics on that sheath combined with cell phone and vehicle records all point to Koberger as the killer.
I am going to leave the bail set of this case as no bail.
28-year-old PhD student Brian Koberger will have to fight his murder case from behind bars for now. At his first court appearance, Idaho prosecutors argued he was a flight risk because police found him 3,000 miles away from the murder scene at his parents' home in Pennsylvania. It turns out that house is where critical DNA evidence was harvested from the trash. According to this unsealed affidavit of probable cause, first, an Idaho lab located a single source of male DNA left on the button snap of a knife sheath next to one of the stabbing victims. Then, Pennsylvania agents recovered that trash from Koberger's family residence. DNA from the trash and DNA from the knife sheath identified a male who could not be excluded as the biological father of Koberger. Koberger's father is not accused of any crime. This is police body cam video showing both father and son pulled over for tailgating as they drove cross country from Washington State to Pennsylvania about a month after the stabbings. Brian Koberger was arrested in his family's Pennsylvania home last week. The public defender who represented him said Koberger planned to prove his innocence.
He believes he's going to be exonerated. That's what he believes. Those were his words.
In order to beat the case against him, Koberger will have to explain not only the DNA on that knife sheath, but also cell phone records cited in the affidavit. Before the 4 University of Idaho students Students were stabbed to death. Police say Koberger's phone pinged cell towers near the crime scene on at least a dozen occasions, suggesting he was scoping out his victims. They say his mobile phone did not communicate with nearby cell towers during the hours of the stabbings, but the affidavit suggests that is consistent with Koberger attempting to conceal his location during the quadruple homicide.
And that would be speculative on the part of Payne, who wrote up this portion.
One of the most chilling passages of the affidavit unsealed today comes from one of the two surviving roommates in the apartment. She told investigators just after 4 a.m. in the morning of the killings, she heard crying. She opened her bedroom door and was frozen in shock when she saw someone in black clothing and a mask who walked.
All right, and this is going to be one of the times right here today that I am going to be announcing one of my surprise. This is what I am projecting that's going to happen. After my 12 hours of research, I said, holy crap, I have to change who one of the defense witnesses is going to be. Based on my understanding of State versus Peterson, I believe that one of the witnesses at this suppression hearing is going to be none other than Dylan Mortensen. Wait, what, Lana? Yes. In the ruling in State versus Peterson, probable cause is determined by examining the totality of the circumstances and making a quote-unquote practical common sense decision whether, given all the circumstances set forth in the affidavit before the court, including the veracity and basis of knowledge of persons supplying hearsay information, there is a fair probability that contraband or evidence of a crime will be found in a particular place. When a probable cause to issue a search warrant is questioned on appeal, the reviewing court's function is to ensure that the magistrate had a substantial basis for concluding that probable cause existed. Now, right above that, having concluded in this case that there were no deliberate or reckless material omissions from the warrant affidavit, we will proceed to consider whether the facts stated in the affidavit supplied probable cause for issuance of the search warrant. The district court held that there was no substantial basis to credit certain hearsay information from another informant that was included in the warrant affidavit. In making our assessment of probable cause, we, like the district court, have disregarded this hearsay information. Now, this is why it's important. In this probable cause affidavit, they're relying on the statements of Dylan Mortensen and her description of Brian Koberger, that, or the assailant or the perpetrator. She is saying that she saw certain height and bushy eyebrows. Now, what Payne would have omitted, because it's about the reliability and an officer knowing or should have known the reliability of her statement. Her statement, if said in an interview saying, I was completely hammered, I had been doing this, that, or the other all night, I was drunk, I was intoxicated, I was high, whatever she would have said would have then been known by the police. And then you have to ask yourself, is it material that they left out that Dylan Mortensen said how hammered she was, how intoxicated she was? So at 3-4 o'clock in the morning, she she went back to bed because she didn't think it was in, because she couldn't tell anything, because she couldn't see anything. So Brett Payne is putting hearsay into the probable cause. And guess what? You, as a defense attorney, could then, if you have body cam or record interviews or video interviews of when Dylan is being questioned by authorities and Dylan is saying things that make her, I don't know. He had Bush. I don't know if she is wavering and saying things like that, and then telling the police that she was that intoxicated. Then when you actually apply Peterson and go to certain portions of Peterson, this can be used to say, wait a second, the officer should have known that he was eliciting this information and it was unreliable because she is saying that she is, 4 sheets, 5 sheets, 9 sheets, 3 sheets to the wind. So, omitting Dylan's lack of sobriety at the time of her identification of the perpetrator, is that omission of Payne material? Because it is this bushy eyebrows, right? And this height, right? That they are using to say that Brian Koberger fits the description of the perpetrator. And so is that unreliable? And should, at the very least, Payne puts that in? Should he have said those things?
Right past her and out the apartment's back door. The mask, she said, covered the killer's mouth and nose, but the roommate told police she could see bushy eyebrows, and police described Koberger as fitting her description.
Now, moving on to then number 4. When I say number 4, now the PCA makes sense. After reading the Peterson case, and I'm going to show you guys different things that I've highlighted, the language in the PCA at times we're just like, why would anybody be writing this? So language in the PCA specifically was for this purpose, for this day tomorrow, in my opinion. It was to protect them against a suppression hearing, against a Frank's, hearing. And you guys remember the sentence where it is said that Dylan did not say that she recognized the guy, like that weird sentence. And then the other weird sentence, which is Brian, why would they be saying Brian's phone pinged on the tower on November 14th, but we know that he wasn't in Moscow, right? So what they did in a sense there is they provided those little statements to say, well, we told you that Dylan didn't say that she recognized the person. And you still, like, knowing that piece, you still, gave us our warrant, right? And then we also told you that the pings aren't reliable because it pinged on the tower on November 14th, and we know that he wasn't in Moscow on that day.
And welcome back, everybody. During the Idaho College student murders investigation, Moscow police contacted the makers of the knife believed to be the murder weapon. The probable cause affidavit says that officers found the sheath to a K-bar knife next to Madison Mogen's body. DNA on that sheath helped police connect Brian Koberger to the scene. Now, the director of sales and marketing for K-bar told TMZ that investigators contacted the company about the knives and sheaths they sell, but K-Bar did not have any records of someone named Brian Kohberger purchasing one. Experts say the knife that would fit the sheath is a 7-inch utility knife, commonly used as a tool by campers or hunters. While police haven't found the knife itself, the sheath with Kohberger's DNA is on it. It's a pretty big get for the prosecution. Wouldn't you agree, Terry?
Again, welcome to Truth and Transparency Suppression Eve. Now, let's go to Hector. Come on in. Please give a shake for Hector. All right, Idaho versus Brian Kohberger, Latah County motions to suppress. Now it has obviously been moved, so it is an Ada. But January 23, 2025, which is tomorrow, what to expect. The Franks and the IGG will be going first based on an order governing proceedings for January 23rd and 24th. The hearing set for January 23rd and 24th, 2025 in this matter will proceed as follows. Starting at 9 a.m., which is 11 a.m. Eastern Standard. The court will take up testimony. See that? We got people testifying. Related to defendant's motion to suppress genetic information, that is the IGG, and defendant's motion for Frank's hearing insofar as it regards the IGG investigation. As indicated in the court's oral ruling, this portion of the hearing will be closed. So again, we will be live tomorrow at 10:40 a.m. And then we will be having that link up. And as soon as, it opens up after this part is done, then that's where we go into this part of it, which is following the close of this evidence. The court will take up the following matters, which will be live streamed on a feed available to the public. That's their normal YouTube channel. Again, subject to the court's determination to close any portion of that hearing by turning off the live stream feed as necessary. So at times they will turn off and mute is how I would think that they would do it. But I don't know. And that is A, testimony related to the defendant's remaining motions to suppress. This is what we get to see. B, arguments on defendant's motions to suppress. And C, arguments on the defendant's motion to compel. Right here, since there was some notes here, the court's oral ruling will be followed by a written order. The trial court administrator will cause a notice to be sent to the media and public via the Idaho Supreme Court's social media accounts advising when the closed proceedings have concluded and estimating when the live streaming proceedings will begin. So this is how we're going to be notified. Murky's all over that. And the courtroom itself will not be open to the public. So even if I was there in person or you were there in person or even the families, you're not getting in. So the courtroom itself will not be open to the public because of the need to revert to sealed proceedings on and off throughout the hearing. And then it was then signed. There we go. So what we can expect. This is the order that if I was the defense, I would be putting it in. I don't know what they're going to go with, but this is this is me saying what to expect. This is my opinion. I'd be wanting to go in a certain order. I think it matters, right? With that being said, AT&T number one, it's either going to be AT&T 1, AT&T 2, or possibly, you could throw up the Amazon or even, Kohlberger's arrest with the DNA. But you're going to have to build into everything. And so that's why I'm saying like you're going to be going in a certain order because of the way that things were done. Okay. You don't get to any of this stuff if you're already, you're screwing this stuff up, right? And this stuff was relied upon to get then, this. So I would have to think that they're going to be going in a certain order. But let's say that based on witnesses' availabilities, I have to go then in a different order because based on witnesses' availabilities. So, but if you don't think that there's a reason that you would put effort into how you weren't going to want to present this information, you're wrong. You would definitely want to be in a certain order. It would blow my mind to think that, okay, does it matter here? Well, let's go with this one. Let's start here. So again, this is just how I expect it, what to expect. And this is what's on the table. Obviously they said they're starting with these, they're closed. And then we are moving into each motion to suppress. Now, I believe that the state is going to heavily rely upon the state of Idaho versus Fisher. Okay. And it was a 2004 case that the Idaho Supreme Court addressed critical procedural issues surrounding the defendant's right to a Franks. Okay. And Fisher, by the way, was convicted on drug charges. So that's the type of case that it was. But the preliminary and the primary legal contention was revolved around whether Fisher was entitled to a Franks hearing to challenge the validity of the search warrant affidavit, particularly concerning the credibility of the informant's statements. So this is where I'm going to have some fun with it. Okay. So it's right here. So let's say that, you knew that Dylan was so drunk or high or whatever, that anything that she was saying is just so unreliable. And here you relied upon it in your, to obtain your search warrants, right? In this case, the court emphasized that even if some statements were inaccurate, so listen, just because if Payne made some inaccurate statements, you guys, that is not enough. It is what Judge Hippler is going to write down as he was merely negligent. Okay. But it is not grounds to say, yep, by God, it's Franks. We're getting this Franks hearing. Okay. So the court emphasized that even if some statements were inaccurate without proof of intent or recklessness, they do not meet the Franks standard. The decision clarified that negligence on the part of basically Payne in this situation does not warrant a Franks hearing. Okay. The court also addressed procedural issues, noting that any error in denying the Franks hearing was harmless because Fisher was not entitled to the hearing in the first place. That's why Syray is so important in this case, is because then we go back now. Well, I'll get to Syray here in a minute, but this judgment reinforces the high threshold set for defendants to challenge the validity of search warrants through Franks hearings. It is a high threshold, but I'm telling you, if there is a case that would, there's two cases that I know of right now, actually three, the Karen Reed case, Richard Allen case, and this case. Okay. So right here, this is why it's so important that you have your witnesses and that you have proof upon when your witnesses are going to testify. So for me, by affirming that the mere allegations without substantive evidence, it does not qualify for such hearings. You can't just allege something. You're going to need to back it up. So the court upholds the integrity of law enforcement processes while ensuring that the defendant cannot easily challenge. Then I really snuggled up with State versus Peterson. And in this case, it was a 1995 case where a detective in Clearwater County applied to a magistrate for a warrant to authorize the search of Peterson's home for a variety of items stolen from persons in that area in the previous 2 months. The magistrate issued the requested warrant, and I just want to show you what he said to obtain this. So go like this. That on 12/10/1995, while investigating a burglary, your defendant interviewed a juvenile suspect. This juvenile has been involved in prior burglaries and has provided accurate information when sought about those prior burglaries. This juvenile stated that in regards to this burglary, that a gun, jewelry, VCR tapes, and a Bearcat scanner had been taken to H's residence on Michigan Avenue. The stolen property, minus the Bearcat scanner, was given over to one of these people, aka this person, the half sister of this person, and she left the residence to dispose of it. This occurred on 12/7/1995. Further, the juvenile related that the juvenile was with 4 other subjects, and took the Bearcat scanner to a residence on 114th Street, where the juvenile believes IB took the first load of stolen items earlier in the day. The juvenile stated that the juvenile believes that LB took the other stuff to the 114th Street residence of one Carl Gus Peterson. As he stated, that's where, quote unquote, they get rid of all their stolen property. The juvenile described the residence as a house sitting on the left side of the street after you enter off of US 12. There would be a red car and a gray or light colored Corvette parked in the driveway. Okay. Now, because, so in this situation, think about Brett Payne. So Brett Payne believes that the juvenile would be in danger if his name were revealed. Okay. So Brett Payne refers the court to prior search warrants. Okay. Prior search warrants at the Peterson residence. Brett Payne presented at the Peterson residence during the service of that search warrant and observed a large room with shelves lining the walls. That the shelves were full of tools and electronic items. The stolen police radio was found amongst the stuff. That the entrance to the room was concealed so that the entry was made through a walk-in closet, which was blocked from the other side. That your defendant believes that this room was the quote-unquote storeroom of stolen items. And then, served it. So then here we go. Peterson contends that the warrant affidavit was factually inaccurate as a result of the intentional or reckless omission of material information by Detective Burgess, right? The same thing that Ann Taylor and Brian Kober are alleging, okay? That just those words. Great, awesome. Specifically, he asserts that Detective Burgess failed to disclose in the affidavit that, 1, the juvenile informant expected favorable treatment in his burglary case in exchange for the information that he was providing to law enforcement officers. And 2, the juvenile had been untruthful with Burgess in the past. So basically, when reading, and it said that, the juvenile right here had been, this juvenile has been involved in prior burglaries and has provided accurate information. Okay, like that'd be like a lie, So 2, when this omitted information is considered, Peterson contends the warrant affidavit does not demonstrate probable cause to justify issuance of the warrant. So, because you omitted this, he's trying to say that it's material to tell the magistrate, like, hey, this person has lied to me in the past, though. Okay. So, when this omitted information is considered, Peterson contends the warrant affidavit does not demonstrate probable cause to justify issuance of the warrant. Because the 2nd, 3rd, and 4th warrants, were obtained in reliance upon then, because that first warrant, right? Then everything basically from the execution of the first search warrant, Peterson argues that the evidence acquired pursuant to those warrants also must be suppressed, fruit of the poisonous tree, right? So this is how the courts looked at it. So you have to think about how the courts think about shit, right? So that you can know how to argue it. Thank you so much, Liz. Woohoo! Yay, Liz. Turning people green. That's what's up. Thank you. So a search warrant must be based upon probable cause to believe that evidence of or contraband from a crime is located at the premises to be searched. Where a warrant application is based in part upon the information provided by an informant, factors supporting probable cause may include facts in the affidavit indicating the reliability of the informant and the basis of the informant's knowledge. So now let's consider then this case. This is why I think that Dylan is very important to the suppression hearing. This right here is why I'm like, damn. Okay, because you're using Dylan and the reliability of Dylan's statements that this perpetrator was in fact however tall, Dylan said, and that they had bushy eyebrows. Coming from who? Coming from what? This person had a mask on, and Dylan Mortensen was hammered. Did you tell the magistrate that Dylan Mortensen was hammered and that she admitted to doing all of these things, drinking, doing drugs, whatever, if in fact that happened? Because nowhere in the affidavit does it say that Dylan Mortensen, except for the fact to say that they were out and about on Moscow. Well, what does that mean? Okay. You're going to be able to argue that Dylan said that she thought she heard Kaylee. Right? I think that she could tell the difference between her roommates' voices, Kaylee versus Xana, right? Because in Payne's probable cause, he says, well, that could also have been Xana too because TikTok app was running. What? Okay. You see where I'm going with this? Next. Where the information has come from a quote unquote citizen informant, which not saying that Dylan Mortensen is an informant, okay? But now I want you to think about right here. Think about this. I want you to think about IGG basically being an informant, okay? IGG is like the informant or any citizen out there that provided the tip for them to begin focusing on Brian Kohlberger, right? Okay. Where the information has come from a quote-unquote citizen informant, disclosure of the person's name and address will ordinarily be sufficient to show the informant's veracity and reliability. Now think about this. They didn't want to remember, they don't want to talk about the IGG. They don't want to talk about the labs that were used. They don't want to talk about how the tip was generated, which comes into the reliability of the tip, though. The reliability of the tip. So, like, Payne had a duty, right, to know how reliable is this tip. So, and you would have to think that touch DNA isn't reliable, right? And then so trying to match then unreliable sample of touch DNA, transfer DNA, to then using IGG that, okay, well, that you're going to have to then do some stuff after the fact. Good afternoon there, Boston. Hello. All right. So the additional evidence of reliability may be provided by the informant's acknowledgement that he or she has participated in criminal activity. Okay. If the informant's identity is known, the risk and opprobrium from acknowledgement of criminal conduct is correspondingly greater, and thus the hearsay assertions of a known informant may be given more credibility. Such admissions may not be dispositive of the informant's reliability and credibility, but when coupled with other indicia of reliability in the affidavit, they will support a finding of probable cause. So again, if you were going to tell the magistrate that, guess what, Dylan, this is what she claims, but guess what, Dylan also told me that she was fucking hammered and used fucking, I don't know, whatever. And that she passed out a couple times. She, was throwing up that night, whatever the case may be. Okay. Because there's also going to be something as to why she didn't call 911 for 9 hours, 10 hours, which also goes to the reliability of that this girl was ham. Like she was she was just, that's how gone you were. But remember, they're saying that she was in a frozen shock state. Now, a criminal defendant may challenge the veracity of an affidavit used to obtain a search warrant if the defendant makes a substantial preliminary showing that the affidavit is faulty. And so that brings me to the first thing I told you guys, which was what proffer was made by the defense to push for the Franks, to get that preliminary push. They have to make a substantial preliminary showing that the affidavit is faulty. The defendant will be entitled to an evidentiary hearing then. And your biggest faulty, like the biggest thing that would be faulty is to use Cy-Ray and the data and to show that the data that they said and gave to, Megan Marshall was incorrect. They should have known it was incorrect. Okay. They had the FBI right there working with them. Payne knew it was incorrect. They had all these resources, and there should have been no reason to not have this be correct. They didn't check to see if the scanner was working properly, right? Next, at such a hearing, the defendant bears the burden to prove by a preponderance of the evidence. So you just have to tip the scale, 51% to like 49%. So what that means is that the judge then determines the evidence that the defendant puts forward, comparing it to the evidence that the prosecution is going to put forward. And whoever tips the scale, just that 1%, they go with. So at such a hearing, the defendant bears the burden to prove by preponderance of the evidence that intentional or reckless falsehoods were included in the warrant affidavit. And you cannot just say, yep, this is false. Look at right here. This is totally false. But there has to be this and. And I believe that this case has it. And the and part is that and to the magistrate's finding of probable cause, and were material. So what you lied about or what you omitted, was it material? And absolutely, if the pattern, because you're trying to say there's a couple things. It was definitely material to omit or mislead and have Magistrate Megan Marshall think that you had Brian Koberger on November 29th when the MPD did not. The MPD did not have him until December 19th, and that's on sworn testimony. So they can play it like three different ways there. Either Payne lied under oath back then if he tries to change it, to now. But they did not know. MPD said they did not know who Brian was until December 19th. That probable cause affidavit most certainly provided a chronological way of presenting this information for any person that was reading it would presume that you guys had Brian on November 29th. Okay. That's misleading the tribunal. Number one. Then number two is, okay, then you said, oh, he shut off his phone. Where is there any evidence that he shut off his phone? It was that speculation that he shut off his phone by that MPD officer. Okay. And then number two, here, the proffer is that Cyray and the data, when you actually plot it, shows and proves that it does not go in concert. The phone is not in concert with this car that you're alleging makes this loop and goes like this. That's where it's faulty. And is this material? Well, yeah, because Brian Koberger is not on the 3 to 5 p.m. towers. So that would have been right there. Oh, like, okay, we're striking out there. Then what's the next thing that we go to? Okay, well, we think, we have this white car. We're pathing it, we're pathing it like this. And then it's traveling like this. And then we have the phone because we got it because he gave his phone number on some ticket. So then we were able to put his phone, and then we saw that we had the bushy eyebrows and based off of Dylan's statement. So we were able to obtain a search warrant to just have the 48 hours of the AT&T warrant. And what were you supposed to do with that? Well, then we were supposed to plot it and then show to get the second warrant that it made this loopy loop and came back. Well, you're going to have Cyray testifying to how long that would take if they didn't already do the drive test. Then he's going to talk about how the house wasn't even drive tested. These certain really specific areas that were very, very important to the investigation and to what you're basically claiming would need to be drive tested to be able to plot these points, and they don't have them. MPD just didn't do this stuff. And then, because if they would have, then they would have realized that, no, the phone isn't moving in concert with our thoughts of this white Elantra that's going like this and happens to then be, boom, here's a white Elantra on WSU's campus that we see, or, this white sedan that's at 526. We didn't do the drive test on the main street that connects basically that main highway part that connects Pullman and Moscow. And Cyrus said, well, if there's ever a case that you would need to drive test that area, this would be that case when you're alleging that the victims were on Moscow's campus and that the suspect is coming from WSU's campus to Moscow's campus. And so you'd want to drive test that area to see what it would look like. And that data it was never drive tested. And Cyrus testified that in the beginning of December of 2022, that there was 4 or 5 days that they went out there to try to drive test, and they were just, 3 minutes and 2 minutes. And this is what proffers would be. And so it's all Cyrus testimony there with the data. And then that's what you relied upon. When I say you relied upon, is Magistrate Megan Marshall relied upon to issue then these search warrants. Next. So the big and there, and were material to the magistrate's finding of probable cause, or that the material exculpatory information was deliberately or recklessly omitted. So this is your big section here. And you have to ask yourself, because I'm going to tell you, you just can't even show just a little bit of something like, you'd want to show the case because you're going to see how they rule on this. If this person had lied before, you want to show the case that the person lied before, get the transcripts, provide those transcripts, and say, yeah, this is how this officer knew that eliciting information from that person that they lied before. And then so just believing what they had to say here, it's just unreliable. And you're acting like it's reliable. And meanwhile, you know that it's not reliable because they have lied before. But when I'm saying that you have to even the testimony of that person, I wouldn't even just go with it. That's enough. Here you go. An omission of exculpatory facts is material only if there is a substantial probability that had that omitted information been presented, it would have altered the magistrate's determination of probable cause. And so what would alter Megan Marshall's decision to award these search warrants? Let's see, where did I put? Hang tight 1 second. All right. So again, any omission of exculpatory facts is material only if there is a substantial probability that had omitted information been presented, it would have altered the magistrate's determination of probable cause. Now, this is where I said, okay, if they were going to use Bethany in a preliminary hearing, why wouldn't they be using Bethany in their motion to suppress, right? Because she's their witness that they were going to be relying upon to provide contradicting statements, because in and of itself, it's exculpatory to Mr. Koberger. So Lana's come with her second bomb. Is Bethany going to be testifying in this proceeding? Because you need to throw everything out there, right? And if Bethany is going to testify that Dylan wasn't even there, or that Dylan stayed down with me in that first bedroom. So I have no idea how Dylan could have ever seen anybody unless it was from downstairs, or we saw a masked man because Kaylee came home. And when Kaylee and Maddie came home, they said that they saw a masked man out when they were taking Murphy out. Okay. So then she's just confusing the two situations, that there was never really a masked man. The masked man came from, earlier statements. So ask yourself, because I had to ask myself if I am an attorney here and I'm putting my best shit forward because I know what I have to overcome and I need certain people to overcome my burden, then how am I not having, Bethany and Dylan? If Payne relied upon those people, right? Like he said he did in testimony under oath, and then with the probable cause affidavit. And if he just purposely just like totally omitted what either one of these two people said in a different interview, or here, this is what she said here, like, how are you, blah, blah. So So do I call it here? Do I think that Dylan and Bethany, why the courtroom would be closed, why nobody's going there? Could Bethany and Dylan be part of that reason? And then they're just Zooming. Yeah, I'm going to have to say, I'm going to put, yeah, that's my second, like, they provide the hearsay that Payne relied upon in his affidavit, which is crucial to the time frame of the crime. The time frame of the crime is between this window and this car. And if you have Bethany and Dylan saying that this happened at a totally different time, then that's exculpatory, right? It has nothing to do with that white car. So think about what you're trying to suppress and why, and where you're going to get the evidence to overcome your burden. And you're going to need it in the form of, I believe, data, witness testimony. And so I got Cyree, Bethany, Dylan, and now who else? Well, Lana, do you think that law enforcement is going to be testifying? Absolutely. I do. Because wait for this. Whether an omission from a warrant affidavit was merely negligent or an innocent mistake, or was made intentionally or recklessly, is a factual determination that we will not disturb on appeal unless it is clearly erroneous. You are going to have to pull and show that this is such a clear erroneous, like, holy shit. And what is that? And that is the phone and the car. And trying to say that a car, out of all of these vehicles that there are in the world of white Honda Elantras, that you picked out one that's over there at WSU, but you're not connecting it to anything between, you're just plopping down, and now you're picking this car, which is totally the wrong year, that federal agent is going to testify to the fact that it's a 2011 to 2013, and Brian Kober doesn't have a 2011 2013, and they knew that. And so they changed it in the affidavit to expand it to act like it was a 2011 2016, which is complete and utter, that's erroneous. That's just a complete erroneous statement. So connecting and saying that you believe that suspect vehicle 1 is Brian Koberger's Elantra, which is the one that's on Moscow's campus, is an erroneous statement because you knew, Payne, that Brian Koberger did not drive a 2011 to 2013 Hyundai Elantra. And that even when you went back and asked an FBI agent, do you think that it could be? And they said, no, I'm most comfortable saying this. It was a different car. And then nowhere in the probable cause do you say that then you went and located Brian's vehicle, took pictures to then prove that Brian Koberger changed the appearance of his vehicle so that it made it look like on cameras that it was a 2011 to 2013. Now, something that we do consider in setting up for an appeal here is whether a misrepresentation or omission is material, however, is a question of law over which is exercised free review. So this, regardless, will be appealable because of the way that they're going to present this. Okay? Which is huge. So this is definitely set up for an appeal if this is all, let's say, denied. A, omissions from warrant affidavit. The district court found that Peterson did not meet his burden of proving that the detective alleged omissions of information were deliberate or reckless. And so when you read these as an attorney, you know what you have to do. Ann Taylor has to prove that Payne, to win that Frank's, okay? I'll make some banging baklava. Oh yeah, woo! Ann Taylor's gonna have to show that Detective Payne, his alleged omissions of information were deliberate or reckless. The court found that the omissions were at most negligent. In this case, that they were most negligent, and that's not going to be enough. But ready? In this case, Peterson, the excluded facts have not been shown to be of such significance that the omission could only have been intentional or reckless. Because on appeal, what Peterson was arguing is that because the detective had knowledge of the omitted facts, he must have omitted them intentionally or recklessly. And such an argument is so stupid because it doesn't mean that. Because we have to consider the fact that you're just a fucking dumbass. And so I believe that the state is going to heavily rely upon this, basically saying that, remember you guys all asked, like, why would Payne ever be in charge? Well, Payne was in charge, I think, for this specific reason. An inexperienced police officer. So on appeal, Peterson argues that because the detective had knowledge of the omitted facts, he must have omitted them intentionally or recklessly. Such an argument is unpersuasive. If accepted, it would mean that every omission of a material fact known to an officer must be deemed to have been made intentionally or recklessly. And I completely agree. However, pertinent legal authorities clearly recognize that misrepresentation or omissions may be merely negligent or innocent mistakes. And if they fall in this category, they do not invalidate a warrant, right? Which I totally agree. Absolutely. 100%. That's in this case. So because he didn't tell the magistrate that, oh, hey, this person provided me accurate information, but they've also provided me inaccurate information. That's what he omitted. Okay. Now, Whether an omission was intentional or reckless might be inferred in part from the relative importance of the information and its exculpatory power. And is it exculpatory for Bryan Kohberger that the Moscow white vehicle is a 2011, 2013, and he owns a 2015? Fuck yeah, it's exculpatory. Now we're talking about something completely different. Again, in this case, in this Peterson case, the excluded facts have not been shown to be of such significance that the omission could only have been intentional or reckless. With respect to the omitted fact that the juvenile informant had lied to the detective Burgess in the past, the only information in the record is Burgess's testimony that he is, quote unquote, pretty sure that the informant had lied to him from time to time. There is no evidence as to what these lies consisted of. So now, ready for this? Lana, how important are your videos that you put out there for the noise complaint? I believe the noise complaint videos provide evidence that you can prove that these students on the Moscow campus lie and that the police officers know that they lie. Moving on. There is no evidence as to what these lies consisted of, whether they were given in the context of a criminal investigations or whether the circumstance of those lies would lead one suspect that the juvenile was lying to Burgess in the present case. The mere fact that the juvenile had at some point in the past lied to Detective Burgess about some unknown subject is not of significant magnitude to compel an inference that the detective intentionally or recklessly omitted this information from the warrant affidavit. Now, think about what we're talking about in this situation. Right here. Now compare that to the lie or the omission or the deliberate disregard for the truth by saying that the Moscow white vehicle was a 2000 and all the way now to 16, from 2011 to 2016, to include Bryan Kohberger and his vehicle, when Payne knew that it was a 2011, 2013. And even going back and asking that officer in the FBI, like, what do you think? Well, no, I'm most comfortable saying it was 2011, 2013. And Payne put in his affidavit that suspect vehicle 1, he believed was Bryan Kohberger's, who does not drive a 2011, 2013. They use amazing resources and computer-based programs and software to determine this. And nowhere does Payne say that Bryan changed the appearance of his vehicle to hide reflectors to make it look like his vehicle was a 2013 or 2011 or 12 because we couldn't see the reflectors underneath. And the reason we couldn't see them, which led us to believe that it was a 2011, 2013, is because he actually covered them up. And we actually have photographs of the vehicle having, you know, if you cover it up with whatever adhesive or whatever the hell, something that had adhesive on it that would have then been able to take a picture and yada, yada, yada. So we are talking about, does the defense have strong evidence that is material that Payne lied about in the probable cause affidavit? And my answer to that is yes, but you're going to have to present it in a way that you're using all of the case law that they're going to use, and you need to spin it. Now, listen to how they look at this. This is interesting. Listen to where the head of a judge is. The second fact that Peterson contends is that Burgess omitted was the juvenile's expectation of a favorable treatment in return for providing information to the police. This court fails to discern how such omitted information would be exculpatory or tend to undermine the credibility of the juvenile, and therefore perceives no basis for inferring that the omission was deliberate or reckless on the part of Burgess. In the context presented here in this case, the informant's anticipation of a favorable treatment in exchange for information would logically tend to bolster, not diminish, the informant's credibility. So basically the judge is like, well, I think it's the opposite way. Like, they would have a very, to be honest, because if we find you lying, then you're not going to get this favorable, treatment. And so because of that, this is the logic. Okay. So, because of that, that is true, because in this circumstance, an informant would be expected to recognize that favorable treatment would be contingent upon providing truthful information. And the informant would stand to lose any benefit from the bargain if he or she were to lie to the police. Thus, Peterson's assertion that Detective Burgess must have intentionally or recklessly omitted this information has no underpinnings in logic. Okay. So maybe people need to start wording it differently, that and how they present it, or if you or you just think that this a judge is just always going to be like, no, I can just spin it. This is complete spin. Because actually in this case, what the guy said, that was the informant, said that I gave up somebody else's name. I said it was Johnson. And then they wanted me to change, then I felt like, okay, I said it was so-and-so's name. Or actually that was in another case. But how do you tell a judge, well, hey, they did all this other shit that you don't think that it's logical that they're then going to tell an informant what to say and how to say it? And here's the information that you're going to use and say. Wouldn't that be logical if they did all this other shit? But I'm not going to, I'm going to pick and choose my battles with a judge, and a Hippler judge, he's not going to go for that. So that's not ever going to be one of my fucking arguments with someone like him. Peterson also has failed to show that the omissions were material in the sense that there is a substantial probability that had the omitted information been presented, it would have altered the magistrate's finding of probable cause. And here's where I believe Brian Kober has the best grounds, is that I do believe that the stuff that was done with you guys chose to completely not tell the truth on how you did all of this, and that the FBI had Brian's name in, November, and that we got the IGG back right away, and we'd been monitoring him, and they were doing all this stuff. And then they were working with us so that we can then go and get search warrants for this because we use IGG and blah, 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 right? They chose not to do any of that. Because for all we know, maybe the FBI was like, I don't know. We don't know if we don't know if it's him. Oh, it's fucking him. And we're got all this pressure. We got to go arrest him and bring him. I mean, we don't know how the FBI feels about this. We have no idea how the FBI feels about this. But if you go and listen to Payne's interview on December 21st or 22nd, when he is putting it out there to the public that Moscow Police Department has always been in charge of this. We've always been in charge of this. This is our case. Well, I don't know who you're telling that to. Why? I mean, what's the problem? What's going on? Again, I think the Moscow Police Department was using those little pressers to basically like jab at the G's, if you really think about it. Because who's saying that? Is the Moscow Police Department really in charge? It's so stupid. So would it have altered the magistrate's finding of probable cause? And then this little shit right here, I think it's just so fucking amazing. So for the reasons stated above, the omitted facts have not been shown by Peterson to substantially undermine the juvenile informant's credibility, and therefore it is most unlikely that the inclusion of the information would have affected the magistrate's probable cause assessment. Ready? Now, in his appellate brief, Peterson also argued that Burgess did not disclose that the juvenile was, quote unquote, part of the criminal malcu at oral argument. However, then he withdrew it because he knew better. But right here, furthermore, Peterson initial assertion in applies in his appellate brief that the informant's identity was not known to the magistrate, even if it were supported by the record, would be of no significance. Ready? So Peterson's trying to say that, hey, the magistrate didn't even know who this informant was. And if the magistrate would have known who this informant was, blah, blah, blah. Ready? Now, this is going to blow your minds because this is how I would spin the shit out of this. Now, if I was the defense team, I starred this little portion of it. And I said, oh, wow, look at this. It is not whether the magistrate was aware of the it was not whether the magistrate was aware of the informant's identity, but whether law enforcement officials knew the identity that is important. So then I started thinking, and I'm like, well, how the hell? Oh my God. So here, MPD, right? MPD, do you guys even know who did the IGG work in the case? It is not whether the magistrate was aware of the informant's identity, but whether law enforcement officials knew the identity that is important. So now take out the word informant, okay? And remember, they wanted us to be all confidential informants, right? Okay? You need to know the person that would have been supplying the IGG tip and how they went about it and what lab they used and all this stuff, right? To know the reliability of it, right? And so right here it says it's not of importance to the magistrate, but law enforcement better know all those details because then they're signing an affidavit, right? But then I said to myself, oh wait though. They didn't ever talk about the IGG. Au contraire. They talk about it in the last motherfucking paragraph to get his arrest. To get Brian Koberger's arrest. And so to sit here and say that, oh, then so-and-so compared this because they took out of the trash the dad's and the mom's garbage, and then we tested it. Like, wait, excuse me, we did what? Who did this? How did we do this? Who did any of this? What's the reliability of any of this? And so I was like, is there a way that the defense can use that, can swing and use that? And having concluded that there were no deliberate or reckless material omissions from the warrant affidavit, we will proceed to consider whether the facts stated in the affidavit supplied probable cause for issuance of the first warrant. And the district court held that there was no substantial basis to credit certain hearsay information from another informant that was included in the warrant affidavit. In making our assessment of probable cause, we, like the district court, have disregarded this hearsay information. Probable cause is determined by examining the totality of the circumstances and making a practical, common sense decision whether, given all the circumstances set forth in the affidavit before the court, including the veracity and basis of knowledge of persons supplying hearsay information. So Payne supplying the hearsay information. Remember? Payne. there is a fair probability that contraband or evidence of a crime will be found in a particular place. When probable cause to issue a search warrant is questioned on appeal, the reviewing court's function is to ensure that the magistrate had a substantial basis for concluding that probable cause existed. The totality of the circumstances in this case, not Brian Koberger's case, but in this one that we're talking about right now, supports the finding of probable cause. The juvenile told police that he had been a participant in burglaries. He specifically informed the officer that he, with 4 other people, took a stolen Bearcat scanner to Peterson's residence. This fact was within the personal knowledge of the informant. He also said that Peterson's residence was where, quote unquote, they get rid of all their stolen property. From the context, the magistrate could reasonably infer that this also was a matter within the informant's personal knowledge. The juvenile identity was known to Burgess, and this fact, as well as the juvenile's acknowledgement of participation in criminal activity, tend to enhance the reliability of the information. So now, how reliable is Dylan Mortensen's statements that the guy had bushy eyebrows, okay, and that he was, 5'10" or whatever, not muscular, skinny, kind of whatever. How reliable is that if Payne knows that that's a party house and that there's all this underage drinking, that they get called over there all the time for noise complaints, that these people lie to them all the time, that they're involved in the Greek life, and that they have to threaten them with, oh, we're going to go tell the Greeks, and blah, blah, blah. And so, and on top of it, that Dylan Mortensen said she was sleeping downstairs. Oh, wait, now she's upstairs. And now she told you how freaking hammered she was and all the stuff that she was taking. And she didn't call 911 for 9 or 10 hours because she didn't wake up because she was passed out until that time. Now, how reliable now is Dylan Mortensen's statements? Then you omit what Bethany said because Bethany contradicted what Dylan said. So when people want to talk about, does Brian Koberger have a chance, even though this is such a high threshold? The high threshold is with the Frank's hearing. But as far as suppressing things, oh my God. I personally think it's a walk in the park because I personally think that things are going to come out in this suppression hearing that is not normal. So when you ask law enforcement if anybody would ever do this or would this make it faulty or whatever, they're like, who would ever do that? And I'm like, well, in this case, yeah. That's why this case is special to somebody like me that wants to look into it. With that said. Woohoo! So what do you guys think? Did you learn anything? Did you learn anything?
This is the mini-series of the University of Idaho murders. Episode 1.
We're starting to win over Bonner.
Some very interesting details about why investigators have linked him to these murders. One, the biggest clue so far is a tan leather knife sheath that was found next to one of the victims. They found DNA on that knife sheath. And as they were investigating a 2015 white Hyundai Elantra, they linked it to Kohlberger, and that's when they really started surveilling him. They found some trash at his parents' house and they took some DNA from that, and that's how they were able to get a match to link him based upon the fact that cell phone records, the forensic evidence there, the several. They're saying that there were 12 different times that his cell phone pinged near that residence before the murders, and they say that that's usually an indication that someone is staking out a crime scene before they actually commit those murders. Vicki, Savannah?
Dana, these clues coming out of the affidavit showing why he was arrested. We know that he is going to make, or has made, his first court appearance back there in Idaho. Walk us through what happens next.
Question: have you read, seen, or heard if police found a knife sheath on the bed next to one of the victims? Question: have you read, seen, or heard that DNA found on the knife sheath was later matched to Brian Kohlberger?
The damage has been done. We've been working very, very hard to keep the sort of noise out of the case. And now it's been injected, at least to these 400 people.
Nobody's injecting anything into the case. A random small percentage of the population is contacted. Have you read, seen, or heard things that are lifted straight out of the media?
And wax their asses, baby. Woo! Show them what's up, Annie.
To a courtroom today. He's charged in the stabbing deaths of 4 University of Idaho students last November. The defense today questioned the validity of the DNA found in the knife sheath allegedly connecting Kohlberger to the murders. They are demanding more information about that DNA from the prosecutors.
They have provided full discovery for the sheath, the DNA found on the knife sheath, but not the other 3 unidentified male DNA samples.
Prosecutors say they've handed over what they have.
We have given the defense everything that we received from the lab. They've asked for DNA workups on other people. To the extent that they don't have them, they weren't done. We can't produce something that doesn't exist.
Police arrested Kohlberger at his family's Pennsylvania home back in December, more than 6 weeks after the gruesome murders set off panic on the Idaho college campus. His attorneys argue he's innocent and was out driving alone at the time of the murders.
Is that a strong alibi?
No, it is not.
Criminal defense attorney Joe Tamburino, who is not part of this case, says it's a weak argument.
But an alibi defense is not, I simply wasn't there at the time. It's you must provide specifically where you were, time, place. Also, if you have any witnesses.
The defense had also been trying to delay the trial. Just moments ago, the judge ruled the trial will continue as scheduled in October. The victims' families were inside the courtroom and said they are optimistic.
College student killings. New documents just unsealed show that prosecutors say DNA left on a knife sheath was used to link Brian Kohlberger to the murders. And one of the surviving roommates came face to face with him that night. News Force Chris Glorioso has been looking at it. He's in the newsroom with details. Chris?
David, police believe Brian Kohlberger was a sophisticated killer using his advanced knowledge of criminology to try and outsmart investigators. But the court documents released today say he made a monumental blunder, leaving that knife sheath next to one of the victims. Police say forensics on that sheath, combined with cell phone and vehicle records, all point to Kohlberger as the killer.
I am going to leave the bail set of this case as no bail.
28-year-old PhD student Brian Kohlberger will have to fight his murder case from behind bars for now. At his first court appearance, Idaho prosecutors argued he was a flight risk because police found him 3,000 miles away from the murder scene at his parents' home in Pennsylvania. It turns out that house is where critical DNA evidence was harvested from the trash. According to this unsealed affidavit of probable cause, first, an an Idaho lab located a single source of male DNA left on the button snap of a knife sheath next to one of the stabbing victims. Then, Pennsylvania agents recovered that trash from Kohberger's family residence. DNA from the trash and DNA from the knife sheath identified a male who could not be excluded as the biological father of Kohberger. Kohberger's father is not accused of any crime. This is police body cam video showing both father and son pulled over for tailgating as they drove cross-country from Washington State to Pennsylvania about a month after the stabbings. Brian Kohberger was arrested in his family's Pennsylvania home last week. The public defender who represented him said Kohberger planned to prove his innocence.
He believes he's going to be exonerated. That's what he believes. Those were his words.
In order to beat the case against him, Kohberger will have to explain not only the DNA on that knife sheath, but also cell phone records cited in the affidavit. Before the 4 University of Idaho students were stabbed to death, police say Kohberger's phone pinged cell towers near the crime scene on at least a dozen occasions, suggesting he was scoping out his victims. They say his mobile phone did not communicate with nearby cell towers during the hours of the stabbings, but the affidavit suggests that is consistent with Kohberger attempting to conceal his location during the quadruple homicide. One of the most chilling passages of the affidavit unsealed today comes from one of the 2 surviving roommates in the apartment. She told investigators just after 4 a.m. in the morning of the killings, she heard crying. She opened her bedroom door and was frozen in shock when she saw someone in black clothing and a mask who walked right past her and out the apartment's back door. The mask, she said, covered the killer's mouth and nose, but the roommate told police she could see bushy eyebrows, and police described Kohberger as fitting her description.
Woo! Suppression Eve!
And welcome back, everybody. During the Idaho College student murders investigation, Moscow police contacted the makers of the knife believed to be the murder weapon. The probable cause affidavit says that officers found the sheath to a K-bar knife next to Madison Mogen's body. DNA on that sheath helped police connect Brian Kohberger to the scene. Now, the director of sales and marketing for K-bar told TMZ that investigators contacted the company about the knives and sheaths they sell, but K-bar did not have any records of someone named Brian Kohberger purchasing one. Experts say the knife that would fit the sheath is a 7-inch utility knife, commonly used as a tool by campers or hunters. While police haven't found the knife itself, the sheath with Kohberger's DNA is on it. It's a pretty big get for the prosecution.
Love you. Love you guys. Love you. I love this one. I love going to sleep in shock. Getting a nice 8 hours feels good. Woo! Woo, 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 woo. This is me driving along Taylor here. Yeah. Yep. This is post demolition. I was doing a drive test, clearly. Woo! I'm down here in Georgetown in out by Washington, D.C., going into these bars where they're going to blast every court hearing. They have like all these TVs going, and it's just wild. Everybody just loves the law down here at Georgetown. If my kid wants to go to Georgetown, I mean, it's so expensive to go to Georgetown, but I know they'll be doing some serious day drinking. Woo! You know how we party for like, Buckeyes games, and it's like Sunday night, Monday night football, Friday night lights, Saturday during the day. No, these college students, these business professionals, they go hard at noon. They just love the law. They want to just watch cases that challenge our rights, the Constitution. They literally tailgate for the law, for our rights. Go Hoyas! Let's see how good the chat is. Name me a Georgetown basketball player of the past. Let's see if everybody knows who the Hoyas are. I love this one. I love going to sleep in shock, getting a nice 8 hours. I mean, how is that logical? Explain that to me. Like, that's why I went over these Peterson case. How is that logical? That somebody would be frozen in shock and then gets a nice 8 hours and then wakes up and summons people over to the house, and then they just decide, okay, you can use my phone, but I'm not going to be the one that calls. And then, you know, again, this is all live footage from Moscow, Idaho, right after the demolition. We were checking out the dog barks. We were checking out that you get the service is so shitty there. We were checking out if you could hear somebody screaming. What else were you doing down there? Georgetown Hoyas. You guys remember Gray Hughes? So that, by the way, that was just a sheet of ice. Like, if you were to try to go down, that was just a sheet of ice. But Gray Hughes, this is right where the incident was, where he was chased out by Kane, the property owner, when Gray Hughes was trying to show his video of the cameras. Gray Hughes is met with rental property owner Kane coming out, basically, you know, saying, "Get over here! Why are you running from me? Get over here! Get over here!" And there you see Gray just running like a little girl. Cheers to all the little girls out there, though. Suppression Eve! All right, guys. Join me later. I got more coming. This is Suppression Eve. We're round the clock Idaho4 coverage. Tomorrow for me is the trial, because everything, what happens in this court proceeding tomorrow is literally going to tell us so much about how in August, when the trial kicks off, what's in, what's out, why. So join me. Thank you, guys. Thank you, moderators, subscribers, members. Make sure you guys hit the thumbs up on your way out. I work just as hard as mainstream media, and I bring receipts, not clowns. Much love. Peace.